As I've already pointed out in the previous video, that the whole idea behind sale of goods contract is to ensure that ownership transfers from the buyer to the seller. But as a general rule, okay, the goods, or rather, one cannot sell what he doesn't have or she doesn't have, just as much as one can't give a better title than the one he or she has. That, in essence, forms the basis of the doctrine of Nemo Dat Quod non Habet. If the seller does sell what he or she has no authority to sell, the buyer will be obliged to give the thing up to the true owner, generally without any recompense for him or her. So, does this mean that everyone only sells what he or she actually owns? Well, in this video, we find out. Now, before we jump into what exactly Nemo Dat is, let's first of all start by looking at this case. The case is that of Greenwood v. Bennett. Now, in this case, the original owner of a Jaguar car entrusted it to a man named Sally for repairs to be carried out. Sally then used the car for his own purpose, crashed it, and caused extensive damage. Now, Sally then sold the car to Harper, who owned a garage, for £75. Harper did not realize that Sally was not the owner of the car. Harper then spent £226 repairing the car and sold it to a finance company. So in this case, we have the owner of the car who entrusts it to his friend. The friend crashes the car, sells it to somebody else who fixes it and then sells it. So it was held in the court that the car belonged to Bennett. Bennett was the owner of the car, the original owner of the Jaguar. The car belonged to Bennett as Sally did not have the title and could therefore not transfer the title to Harper. For the same reason, Harper could not transfer the title to the finance company. Bennett was therefore able to recover the car but had to compensate Harper for the work done to it. The principle of Nemo Dat, Nemo Dat Quod non Habet, is one of those common laws principles that was developed to protect true owners when it comes to issues regarding their goods, like in this case. However, its strict application interferes with commercial transfer in that bona fide purchasers cannot acquire a good title if the sale had none. Actually, the effect of this can be seen in one of those cases that was presided over by Lord Denning. The case was Bishop Gate Motor Finance Corporation v. Transport Brakes Limited. Now in this case, Lord Dennings made the following remark. In the development of our law, two principles have striven for mastery. The first is for the protection of property, that is, no one can give a better title than he himself possesses. The second is for the protection of commercial transaction, that is, the person who takes in good faith and for value without notice should get a good title. The first principle has held sway for a long time, but it has been modified by common law itself and by statute so as to meet the needs of our own times. Now, meeting the needs of our own times kind of is interesting, but the whole point is you're just saying that in as much as we have Nemo Dat, in as much as you can't give what you don't have, or rather you can't sell what you don't own, or basically you can't give a better title than the title you have, there in fact are exceptions to these rules. So let's talk about that. Let's talk about exceptions to the Nemo Dat Quod non Habet. Estoppel is the first exception. So with Estoppel, this is what I'm talking about. You own your laptop or your phone, right? So if I'm supposed to be, let's say you want to sell your laptop, and then I'm with you, we are standing somewhere, and then this buyer comes along, and then I tell them that, look, I'm selling the laptop, so I'm selling the laptop, your laptop, Like I'm selling the laptop for this much, and you're just standing there, and you are hearing this entire conversation, and you're not trying to stop this buyer, this third party, from actually giving me money and expecting me to give them the laptop. Then you will be prevented, you will be estopped. That's what estoppel means. You will be estopped from denying the fact that you actually approved the sale as far as your laptop is concerned. So in that case, I will be selling what I don't own. And so that's the first exception. That is the estoppel as an exception to Nemo Dat Quod non Habet. So remember, if you're just there and you're aware that somebody is trying to sell your property, and you sort of, by your behavior, it's implied that you agree with them, then you can't later try to deny that fact. The key thing is that you have to be aware that that is happening. Exception 2, sale by a mercantile agent. Mercantile agents are the sort of agents who sell using their own names. Now, these are the kind of people you meet when you go to the bank. I mean, when you walk to the bank, the guy who solves your account-related issues, that guy is not the owner of the bank, okay? But the sort of operators, though they are, they sell your account. The same can be said about certain insurance agents or even certain car dealers. So, these are people who are selling things that they don't own, or they are giving titles to properties or whatever it is that they don't have. Exception 3, resale by a seller in possession of goods or document of title. Now, this one usually actually emerges in most of the fraud cases where a seller sells you something, but they don't really give you the title or the documents. While you're waiting for the documents, they sell it to somebody else. Now, the other person who buys in good faith is actually going to be the true owner of those things. So the only thing you can sue the seller for is recovery of your money, and not necessarily to get those whatever it is that you wanted to buy. Next, sale by a buyer in possession of goods or document of title. And last, sale by a person with a voidable title. Voidable title, okay, when talking about the law of contract, we're talking about, there are 3 situations. There is a valid contract, there is a void contract, and there is one that is in between valid and void. So in this case, when you say something is voidable, you're saying this thing can either be valid or void depending on the circumstances, okay? Here's an example. If A, by fraud, obtains goods from B, A has a voidable title to the goods, and B can, on discovery of the fraud, rescind the contract. If A, before B resigns the contract, sells the goods to C, who buys in good faith, and in ignorance of the fraud, C will get a good title. Then again, if A, after B has rescinded the contract, sells the goods to C, the latter does not acquire a good title unless C is protected by one of the provisions in Sale of Goods Act, protecting the purchaser in good faith. Well, that sort of covers transfer by a non-owner, or rather the doctrine of Nemo Dat Quod non-habet. Of course, sort of trying to summarize these things in video form. There's going to be a written description, rather a written sort of booklet regarding this entire video and series of videos that came before it. So make sure you download that and read along as you are, continuing with your studies. I'm Moses from Zerite Network, and I'll see you in the next lesson.